School Counseling Principles, Ethics and Law, Chapter 6, Obligations to the Court by Ellen Voorhees and Colleen O'Sullivan.
According to School Counseling Principles, Ethics and Law by Carolyn Stone, schools are governmental agencies. The legal authority of schools is as diverse as the 50 states that enact the laws to govern those schools. Even though the United States is composed of a union of states under one central government, America has a unique education system that is governed by the laws of 50 states, with component parts amounting to several thousand local school districts operating units. When a professional school counselor considers obligations to the court, they should always take into account the ASCA ethical standards for school counselors. Court cases begin at the lower or district court level by a plaintiff or petitioner. A plaintiff or petitioner is the one who initiates a court action by filing a complaint with the appropriate court. The court serves a summons on the person or persons named as the defendants. Prior to the trial, there's a process of discovery in which the attorneys may require an oral or written deposition. School counselors are required to testify in a court proceeding. Although school counselors have confidentiality requirements, school counselors cannot deny the courts their testimony unless the students of school counselors are given privileged communication in state statutes.
In general, school counselors are required to testify in court. Counselors have confidentiality rights but cannot deny a court subpoena or order. However, each state may have its own privileged communication statute. A privileged communication statute is a statute that only applies to court proceedings. Only a few states give privilege to students, and if you're working with a state that has a privileged communication statute, you, as a school counselor, are rendered incapable of testifying about your confidential communications with the student. This privilege is not unlimited. In most states that have a statute, the judge can rule that the needs of the state outweigh the right to the privileged communication. You must know the statute of the state you are working in, and it's recommended that you check with your district's legal counsel if ever subpoenaed or receiving a court order to know more about your privileged communication statute. The answer to how a school counselor should behave resides solely in state statutes. In absence of a state statute giving the school counselor student-client's privileged communication, school counselors legally owe the state their testimony. Ethically, the school counselor may try and get out from under a subpoena, and you can consider that in the following video.
Hi, Miss Gonzalez. How are you? It's nice to see you. Hi, Zeke. How are you? I'm doing well. It's nice to see you.
I was wondering if I could speak to you for a second.
Sure. Come on in.
You can stay out.
Okay. I'll talk to you later, Zeke.
Okay.
You want to sit right there?
Sure.
How are you?
Good. How are you?
I'm doing well.
Good. So, I signed a permission slip, and I was wondering if you would like to go to court with me because I'm going through a divorce battle
Okay.
right now.
So, I've been counseling him one-on-one about the divorce and differences in the situation. And so, your husband, both of you signed the permission slip for the counseling. Would you like me to testify for you?
Yes.
Okay.
Given what you've read and learned through this discussion so far, how would you have responded to the mother's request? How would you address the questions about what you've discussed with D, her son? How much would you share? What kind of information would you share? And can you share that information with the mother? Does privileged communication apply in this scenario? A school counselor often works with students who have problems at home that are affecting their school experience. There may be times, like a divorce situation, in which a parent might desire to use the knowledge gained from response services to influence the outcome of a court case. It is important to go over confidentiality with students prior to counseling, so they are aware that information from sessions may be admissible in the court of law. It's also important to stress that to parents that a counselor's role is to provide solutions for students. What we've talked about has been pretty cut and dry, but not all subpoenas are cut and dry. The text gives a scenario about a foster child in a home that he was placed in, selling and receiving stolen goods. I'm going to read that to you, and then we will discuss it. You've been the primary advocate for and confidant for Hansen, who has been in and out of foster homes all his life. He has been in 3 foster homes in the 2 years you have known him. Hansen has a difficult time trusting adults, communicates only when necessary, and is guarded and suspicious. You have painstakingly built a bond with Hansen, albeit a fragile bond. One of the foster families Hansen lived with for 8 months is being investigated for receiving and selling stolen property. You receive a subpoena from the prosecution to give testimony about your confidential conversations with Hansen. Students in your state do not have privileged communication. Hansen, who has already been deposed, was vague and guarded in his responses. The attorneys are hoping that you learned more from him about his time in this home. Hansen told you little about this foster family. What are your legal responsibilities to the court, and what are your ethical responsibilities to Hansen? We have to remember that as school counselors, we abide by the ASCA ethical standards, and ultimately, you are the advocate in trying to protect your student. So that is our goal when being faced with a situation like this with Hansen. Immediately, you should contact your school's district's attorney and ask how to have the subpoena squashed so you don't have to testify. When contacting the legal counsel, you want to make sure that you're citing your ASCA ethical codes, the reasoning behind why you're trying to keep the student's confidence, and try to stay out of the court as much as possible. When talking with legal counsel, give them the information that will help them squash the subpoena. Just don't tell them that you don't want to do it. And advocate. Always keep your student, who is your primary client, in the forefront of your mind in the decisions that you're making. Make sure that you are doing everything in the best interest for that child. If you can't get out of the subpoena, which we always can't, and we do have to show up in court if we were asked, maybe go to the judge and ask to only use notes. Again, use your legal counsel for your district to do so. If you can use the notes, they will be sealed documents, and that will remove you from court and remove you from having to be questioned. So there is a lot of gray area when we are asked to go to court or we are subpoenaed to produce evidence. And we always want to make sure that we are contacting legal counsel, that we understand what our rights are and what we have to do as a school counselor, and that we are keeping the student at the forefront. In summary, again, school counselors are obligated to testify in court. You can't ignore it, you have to do it. And privileged communication is a state-by-state basis, and it must be understood by that state because each state is the same, and each have different caveats that may not always keep that privileged communication unbound. The student's always in the forefront of our minds. It's who we advocate for, it's who we try to keep the confidentiality of, and it's their best interest that we have in mind. And remember, of those surveyed who have, those school counselors who have been surveyed, only 66% have never been subpoenaed. So only a third of school counselors in the past 5 years surveyed have been subpoenaed. So our odds are pretty low, I would say. And again, of those 66%, of those 34% subpoenaed, only 72% were asked to testify in a custody battle, and 52% was for child neglect. So very few are about criminal proceedings against children, and then again, rarely are school counselors ever defendants in the court of law. Thanks so much.